The British Constitution, an uncodified, flexible framework built on tradition, law, and evolution. What makes it unique? Uncodified, not written in a single document like the US.
Or Indian Constitution. Multiple sources, derived from laws, court rulings, traditions, and international agreements. Flexible and evolving, can be changed easily by Parliament to meet new challenges. 5 sources of the Constitution: statute law, acts of Parliament, written laws; common law, judge-made laws from court decisions; constitutional conventions, unwritten traditions and customs; works of authority, legal and political writings by scholars; international agreements, treaties influencing British law.
Statute law, written foundations. Acts of Parliament form the backbone of the British Constitution and can be changed by Parliament at any time. Magna Carta, 1215, established the rule of law. Bill of Rights, 1689, limited monarchy powers and strengthened Parliament. Human Rights Act, 1998, protects citizens' fundamental rights.
Common law and conventions. Common law. Laws developed through court decisions and judicial interpretations over time. Judges play a key role in shaping constitutional principles. Example, the principle of habeas corpus, a person cannot be jailed without trial, was developed through court rulings. Constitutional conventions. Customs and traditions followed by government, though not legally binding. They help run the government smoothly but can change over time. Example, the Prime Minister is always a member of the House of Commons, but no written law enforces this. Works of authority and international influence. Works of authority. Books by constitutional scholars that help interpret principles. A.V. Dicey's Introduction to the Study of the Law of the Constitution defined parliamentary sovereignty and rule of law. International agreements. Treaties between the UK and other countries influence British laws.
The UK was part of the EU before Brexit, and the European Convention on Human Rights still impacts UK laws. Key constitutional principles. Parliamentary sovereignty. Parliament has ultimate power to make or change any law. No court can declare a parliamentary law unconstitutional. Rule of law. Everyone, including the government, must follow the law. Courts ensure justice and protect citizens from abuse of power. Constitutional monarchy. The UK has a king, queen, with limited powers.
Real power rests with the Prime Minister and Parliament. Unitary system with devolution. The UK operates as a centralized system where Parliament holds supreme control, but powers have been devolved to regional governments. UK Parliament, Scotland, Wales, Northern Ireland. Local governments. Some regions have their own governments for local matters, but Parliament remains the highest authority, with power over all constitutional issues.
A flexible constitution. Easy to change. Parliament can modify the Constitution by passing new laws. Quick adaptation. Evolves with changing political needs and challenges. Recent example, Fixed-Term Parliaments Act 2011 changed elections, repealed in 2022. This flexibility allows the UK to respond rapidly to new circumstances, but it also creates potential uncertainty about rights and constitutional rules compared to written constitutions.
Strengths and challenges. Strengths. Adapts quickly to changing needs. Parliamentary sovereignty enables decisive action. Centuries of tradition provide stability. Flexible enough to incorporate modern rights. Challenges. Uncertainty about constitutional rules. Lack of legal clarity compared to written constitutions. Rights can be changed easily by Parliament. Conventions may be unclear or contested. The British Constitution is based on statute law, common law, conventions, legal writings, and international.
Treaties. It is flexible, uncodified, and grounded in parliamentary sovereignty, a living framework that continues to evolve.